Welcome to the Marin Conservation League After Hours event. My name is Paul Jensen. I'm the MC this evening. I'm a longtime member of MCL and I'm recent to the board of directors. We have a lot of folks that registered for this event this evening, and some may be unfamiliar with MCL. So I'm just going to briefly tell you a little about the Marin Conservation League. It's a nonprofit Marin-based environmental organization established in 1934. Its mission is to ensure preservation and protection of natural resources and assets of Marin. MCL monitors a broad range of land use and planning decisions countywide to ensure that Marin's ecological values are maintained and restored. A little about MCL After Hours, which is the event that is being sponsored this evening. It is a webinar forum, and these webinar forums are scheduled to spotlight a topic, actions, or events that are current and critical to Marin and beyond. A guest speaker experienced in or intimately knowledgeable of the topic is invited to speak, and the purpose of the forum is to provide information to and educate those participating. The MCL After Hours morphed from what used to be MCL business breakfast events, which were held several times a year in person prior to the pandemic. A little bit about housekeeping tonight before we get started on the webinar, and that is we are recording this event, so everyone should be aware of that. Secondly, we will ultimately be posting this webinar at some point, either on YouTube or some other format, but that's yet to be determined. We'd like to request that everyone keep their microphone muted so that we don't have any unpleasant background noise. And our guest speaker will be speaking for about 20 to 25 minutes. And following that, we're going to have about 30 minutes allotted for questions and answers. And we would like to ask you that instead of using the raised hand function, if you have a question, please post your question in the chat box. So moving on to tonight's topic, which is the California housing legislation. The question is, how was this topic selected for this event? And simply stated, it's timely, as there are many changes that have occurred or are occurring that could dramatically change how and where housing is developed in Marin and the processes that we have been so accustomed to following for many years. The Marin Conservation League is working to develop an updated housing policy position statement, but because of the many changes, we thought it best to take a pause and get educated on this legislation before moving forward. The housing crisis surfaced sometime after the Great Recession in California, and new employment began to outpace housing development. And housing development was held up due to various factors, including local development review processes. And then what was built was out of reach to many. So the state recognized this crisis, and the legislators started to promote new legislation that would reform or relax some of the laws that govern housing development. And all of this has an impact at the local level, which is why it's important to us. For example, starting in 2017, then Governor Brown signed 17 state and assembly bills creating new and reformed housing laws dealing with this specific topic. And then the following 3 consecutive years, about an average of 15 to 20 bills were signed each year, either with new housing laws or amending those previous laws. So there, as you know, there's been a lot of media attention on this topic. It's been a big learning curve for the public who have become familiar with acronyms such as ADUs, accessory dwelling units, and RHNA, the Regional Housing Need Allocation. And last year, Governor Newsom signed 32 bills, so this momentum continues. So how do we grasp this information, which brings us to our guest speaker? I am honored and proud to introduce Barbara Kautz, our guest speaker. Barbara is a partner at the law firm of Goldfarb and Lipman and is well known throughout the Bay Area for her knowledge of affordable housing and land use law. Her practice includes environmental review compliance, real estate, economic development, and fair housing. And before becoming an attorney, Barbara worked for 30 years as a planner. She was a community development director and assistant manager, ending her planning career in the city of San Mateo. Prior to that, she was the planning director in Corte Madera for 10 years. She is the author of In Defense of Inclusionary Zoning, Successfully Creating Affordable Housing. And the best part is Barbara is local. She's been a Marin County resident for over 40 years. So welcome, Barbara.
Well, thank you very much, Paul. And I think with that, I will attempt to share my screen and give the presentation. I'm on. All right. So this presentation is billed as demystifying the housing legislation, but it's in fact very dense legislation and almost deliberately complicated. So I'm going to do my best to provide an overview, not touch too much on the details, but talk about some of the main principles that seem to animate this, and then have lots of time for questions for people who want to get into more details or don't understand some of these concepts. I'm going to first talk a little bit about the housing crisis, because there really is, in fact, a crisis. And then I'm going to talk about housing elements, which the county and all the cities in the county are now deep into preparing. I'm going to give an overview then of the laws that affect the review of actual housing projects. And lastly, I'll talk a little bit about SB 9, which is the legislation passed last year that effectively ended single-family zoning in the state. So I find this slide about the number of housing units constructed really interesting and somewhat puzzling. So the state is projected to need 180,000 homes annually to keep up with population growth. And you'll see that that's only been accomplished since 2003 years, in 2003, 2004, 2005. There was a crash during the Great Recession, you can see, but you can also see that the housing production has never really recovered. Right now, it's at about 120,000 a year, but it's never really gone above that. And the issue is why has it fallen to such an extent? Cities and counties haven't recently amended all their zoning and planning to keep housing out. In fact, they've been doing the opposite. But nonetheless, the housing market has never really recovered. This is another interesting slide showing single family and multifamily starts. And you can see that the real plunge has been in single family residential starts, with multifamily starts somewhat recovering, but none of them have come close to where the state was in either the 80s or in the early 2000s. Now this shows the effect of the shortage of housing. 80% of lower income renter households making 80% of median income or less pay more than 30% of their income for housing, and almost half pay more than half their income for housing. In Marin, a lower income rental household making 80% of median or less is a couple making less than $96,000 a year, or a family of four making less than $120,000 a year. A moderate income family of four in Marin makes less than $180,000 a year. So we're talking about people with pretty substantial salaries, certainly more than you make working in retail sales or many other types of businesses. Oops. So this housing shortage has many causes. There are labor shortages. Anybody who's tried to find somebody to do remodeling on their house knows that the biggest problem is finding a contractor. Construction costs are soaring. There are material shortages. Building technology, construction technology hasn't increased in many, many years. It's still often hammer and nails. There was a recent article in the Atlantic talking about how large investors have bought up many single-family homes. There's rising inequality, so that while on one hand, many of my friends have second homes, on the other hand, people at the bottom of the pay scale can't, are paying more than half their income for rent. There's Airbnb and second homes, which have led to a lot of vacancies. A number of my clients who live in popular resort areas like, say, Napa County or near the coast have seen rising vacancies in single family homes, and those have taken a lot of homes out of the market. And there's no doubt that zoning and planning approvals and those delays also affect the housing shortage. There's been also a loss of redevelopment funds. The state used to devote $1 billion a year that cities and counties could spend on affordable housing. That money was eliminated with the elimination of redevelopment in around 2012. There have been cutbacks in federal dollars. The state has recently, with the budget surplus, has been putting more money into affordable housing, but frankly, it hasn't made up the loss of redevelopment funds. But nonetheless, the legislature seems to be focusing on zoning and planning approvals as a cause, as a major cause of the housing shortages, thinking that if they can streamline those zoning and planning approvals the state can reach its goal of 180,000 units a year. And so the legislatures, this was in one of the first bills to pass in the avalanche since 2017. And here the legislature indicates that its intent is to curb the capability of local governments to deny, reduce the density of, or render infeasible housing development projects. And the legislature felt that that intent had not been fulfilled, and that's what the legislature, the recent legislation, is trying to accomplish. So how are they doing it? One, the state is requiring many more sites to be planned for higher density housing, and they're doing that through housing elements, which I'll discuss in just a bit. And then once the sites are planned for housing, the state has made it very difficult to deny housing development projects. So let's talk about housing elements. So what a housing element is it's a plan to meet local and regional housing needs. I suspect that the county and almost every city in the county is working on its housing element right now. So the regional agency, the Association of Bay Area Governments, is given by the Department of Housing and Community Development. So I'll be talking about ABAG, which is the regional agency, and HCD, which is a state agency. So HCD gives ABAG the number of units that the entire 9-county Bay Area region needs to accommodate in the next 8 years. And then ABAG decides how many units each city and county must accommodate. And that's called the Regional Housing Needs Allocation. And I'll give you another acronym. It's called the RHNA. So this year, HCD increased the total number that the region had to accommodate by 2.5 times. But the number of units that have to be accommodated in Marin has increased 6 times from what needed to be accommodated in the last housing element. And the number has gone from about 2,300 units total to over 14,000 units total. And this shows the increase in the number of units, the housing units that each community in the county has to accommodate. The county's number has increased almost 20 times, In the unincorporated area, instead of 185 units being accommodated, over 3,500 units need to be accommodated. So what does it mean to accommodate the regional housing needs? Well, cities must show HCD that they have enough sites that can be realistically developed in the next 8 years to meet their RHNA. And this little graphic is one I picked up from a community in Southern California showing their proposed housing element sites. Generally, this is going to require substantial increases in density and upzoning of many sites to meet communities, to meet these numbers. Just to go back one, about half of the units assigned to each of the communities, it varies from maybe 40% to 55%, but about half of the numbers assigned to each community need to be units that have to be provided on sites that are suitable for lower income housing. And those lower income housing sites have to be zoned at least 20 units an acre. HCD reviews each housing element and decides whether or not it conforms with state law. And they're being extremely tough on communities to demonstrate that the sites that they're designating, in fact, are likely to be developed in the next 8 years. Just to give you an idea of how tough they're being, in the Southern California region, which includes San Bernardino, Riverside County, LA, Ventura and Orange counties, where there are hundreds of different communities and where the housing element was due on October 15th. To date, HCD has approved the housing elements of only 3 communities. Their average letter has been 13 pages long. I looked, just out of curiosity, I looked at a presentation a local community had done about their housing element sites. And I thought to myself that HCD would never approve most of the lower income sites they were showing. There was an elementary school designated for 72 units. Unless that school district said that it was actively planning for those 72 units, HCD would no longer, find those units acceptable. So a lot of communities in Marin have shown units on parking lots. Unless it can be shown that those are actually likely to be developed, HCD won't accept them. And so I think, from a conservation standpoint, it's really going to be an issue about whether cities are willing to allow substantial increases in density in their more downtown areas, or if they even have open space, whether that open space should be developed. Anyway, it's going to be a very tough year, and cities will need to show that they can actually build the number of units, that it's actually feasible to build the number of units that they've been assigned. Something that is going to make this even more difficult are what are called no net loss provisions. So let me just run back real briefly. So when cities cities in the county draft a housing element, they need to designate specifically on which sites these units are going to be located. And they need to indicate what income group the site is intended to satisfy. So if, for instance, a vacant single family site would satisfy an above moderate income housing, a site that's zoned for 20 units an acre might be suitable to develop lower income housing. So the no net loss provisions apply when any site in the inventory is either approved at a lower density than is shown in the element. For each site, a community needs to also estimate how many units can actually be built there, or that the site is approved with fewer units at the income level shown in the inventory. So just as an example, This is what an inventory might look like. There's a site designated, the zoning's shown, the density's shown, and a number of units are projected for that site. So and I'm not sure this is visible, but let's say that all these sites are shown to accommodate lower income housing, because they're all zoned at a density that that is considered to be suitable. So let's say that on site 1, only 30 units are built. And let's say that only 10 of those are actually lower income, or are actually going to be developed affordable to lower income households. Then the community that approves the project has to show that they still have enough sites left to meet their RHNA, or they have to upzone another site within 180 days. Now there are not, I think people know that inclusionary zoning typically requires anywhere from 10 to 20% of units in a project to be affordable. And any more than that likely makes development infeasible. Most 100% or all 100% affordable projects need to be subsidized. So there is not enough money in the state to create all the lower income units that the state has assigned to local communities. And as a consequence, cities can expect that many of these sites on sites designated for lower income housing will be developed with mixed income housing without the number of lower income units that are shown. And as a consequence, cities really need to designate a surplus of properly zoned sites, or they're going to be constantly upzoning sites as each project is approved. So I'm going to move now into the review of actual housing development projects after the zoning is taking place, or just housing development projects that are proposed right now. So there's 5 pieces of legislation that are probably most significant. One's the Housing Accountability Act, which actually has been around since 1982. Another is the Housing Crisis Act, which was passed in 2019. A third is SB 35, which passed in 2017, and it's similar to something called by right approvals. There's density bonuses, which allow developers to greatly increase densities. And then there's SB 9, which is the single family provision. So the most important feature of the Housing Accountability Act is it requires that cities make decisions based on, quote, objective standards in their zoning and planning laws. And if a housing development complies with all objective general plan, zoning, design, and subdivision standards, then a city can only reduce the density or deny the project if it finds a specific adverse impact to public health and safety. And what's a specific adverse impact? A specific adverse impact is lack of compliance with an objective standard, an objective quantified standard that was in effect when the project was submitted, or when the project was deemed complete. So it can't be, say, a CEQA adverse impact that is not based on an adopted standard. It has to be something, it has to be based on an existing standard. So what might be an example? So let's say that a community has a provision that power lines have to be undergrounded, right? Which could be considered, and that not undergrounding them in an area, in a high fire hazard area, might have a specific adverse impact to public health and safety. So that might be an example, but it's a very, 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 very narrow exception. And the city has to show, or county, that the impact can't be mitigated in any other way. What's an objective standard? Well, here's the definition in the statute. It's a standard that involves no personal or subjective judgment and is verifiable by reference to an external benchmark. Okay, what are examples? Height, setbacks, lot coverage, open space density, and so forth. What's not an objective standard? Complying, being consistent with neighborhood character, based on health, safety, and welfare, physically suitable for the site, meets demand for senior housing. A community really recently lost a case in the Court of Appeal. They had a standard which their city attorney felt was objectives, saying that if two adjacent structures varied by more than 2 stories in height, those the stories on the new building had to be stepped back. The Court of Appeal said, well, it doesn't say how much they have to be stepped back. It didn't say whether the entire length of the building had to be stepped back. The fact that it wasn't stepped back at all didn't matter because it was considered to be a subjective standard. So the courts have very strict standards for what is an objective standard. I know that cities in Marin in the county are now developing prescriptive standards called ODD standards, objective design and development standards, I think. The court did say that cities can use subjective standards to apply conditions, and that the city we talked about could have required a step back, but any of those conditions cannot reduce the density of the project. So this is a very limited bit of flexibility. The next bit of legislation I'll talk about is the Housing Crisis Act of 2019. And this had a lot of provisions, but 2 of the key ones were, 1, it allowed developers to vest their projects early. And by vesting, it means basically to freeze the cities or counties' provisions that are in place. And the developer can do this by filing something called a preliminary application. A preliminary application involves submittal of a limited list of information, which is in the statute. The city or county can only ask for the information that's specified in the statute. And once all that information is submitted, the city's standards are frozen as of the date of submittal. Another key provision of the Housing Crisis Act is that there's no downzoning allowed. Unless a city concurrently, and it's been defined as in the same evening, upzones other property to make up for the loss of capacity. And the downzoning is defined. It doesn't talk about downzoning. It talks about reduction in housing density. So things that are not allowed unless there's concurrent upzoning are no reductions in height, no increases in setbacks, no reductions in floor area, no reductions in lot coverage, no increases in open space. So all those are, so the Housing Crisis Act doesn't allow any of that. Then there is SB 35 and also by right approvals. And under approvals under either SB 35 or by right, no CEQA can be required. There's no review under the California Environmental Quality Act whatsoever. By right approvals, which I'll just talk about briefly, only apply to projects that have 20% lower income housing and don't need a subdivision. So it's a rental project with 20% affordable housing. A city can require design review based on these objective standards, but that's the only review that the city or county can require. When the new housing elements are done, many sites designated in housing elements will need to be zoned to permit by right approval. If cities want to reuse sites that were used in previous years, many of those sites will need to be rezoned to allow by right approval. Also, if any of the zoning is adopted after the due date of January 31st for these housing elements, January 31st, 2023, then the zoning needs to be by right. So there probably are going to be many more opportunities for by right approvals. SB 35 is in place right now and allows ministerial approval. And the key advantages to the applicant are that there's no secret review. As I said, it's ministerial. It's reviewed like a building permit based only on whatever objective standards are in the zoning and general plan. And if they disagree, the general plan standards apply. There's very strict timelines for city actions. And there's an exemption from all parking requirements if the development's located within half a mile of public transit. Now, there's a number of fairly significant requirements to be eligible for an SB 35. There can't have been any rental housing on the site in the last 10 years. It can't be located in the coastal zone or on ag land. Can't be the site of a mobile home park. Either 10% or 50% of the density of the base density needs to be affordable to lower income households. A project with more than 10 units has to pay prevailing wages, which is a big disincentive to many developers. And as I said, it has to comply with all objective standards. Also, the city has to be eligible for SB 35 approval, and that's based on the city's not meeting its RENA goals for housing construction based on building permit issuance. So this, right now, Corte Madera and Mill Valley are exempt from SB 35, but their RENA goals are far less than they will be in the next cycle. So it's unlikely that any communities will be exempt from SB 35 in the next cycle. And lastly, I'm going to talk about density bonus incentives, which allow developers to really avoid many local requirements if they provide relatively small amounts of affordable housing. As little as 5% very low income units qualify a developer for a density bonus of 20%. So there's a minimum bonus of 20% that a developer is allowed by meeting these minimum standards here. There's a 50% bonus allowed in the number of units when there are only 15% very low income units. And there's an 80% bonus for 100% affordable housing. And that project is allowed unlimited density if it's within a half a mile of a major transit stop. Developers are also entitled to what are called incentives and concessions and waivers. And these are slightly different, but essentially they permit unlimited modifications of local development standards. The development community and HCD argue that essentially once a developer is eligible for a density bonus, they're entitled to whatever design they want and essentially need not to comply with any local standards. This is from the San Francisco Chronicle, and these show some planning diagrams that were prepared for Hines, a developer that owns 50 Main Street. That's the project in the middle. And the two buildings on either side of the middle building are existing buildings. And this one shows that a conforming building, and then they're asking for a 50% density bonus, but one that's twice as tall. And that's the kind of waiver that the development community believes is justified. The state this year set up a housing accountability unit in HCD that has 25 staff members whose charge is to basically hold cities accountable for complying with state law. They've been given broader and broader authority over more and more of the legislation. Typically, they may send cities a letter of inquiry when they get a complaint. They send cities and counties letters of technical advice, meaning this is what we want you to do. And then if they find that the city has violated state law, the city will get a notice of violation. The Attorney General has also announced that he has set up a strike force of 12 attorneys. So none of these bills are laws that cities can ignore. SB 9, the last topic. So SB 9 allows two things. It allows an urban lot split, meaning that any single family lot can be split into two. And it allows 2-unit developments, which is basically allowing 2 units on each lot. Or if someone chooses not to do an urban lot split, they could build either 2 single-family homes or a duplex unit, and 4 units would be possible with ADUs. So essentially, it allows 4 units on any single-family site. So this was a diagram done by a Southern California architect named Alfred Twu, showing some examples of what might be allowed under SB 9. And so his first example is a duplex with a garage in back, but no parking's required if the site's within half a mile of a major transit stop or a bus line with service at least every 15 minutes. The bottom slide shows what might happen with an urban lot split, where there's a duplex in the back and a duplex in the front. The buildings are required to comply with local planning and zoning standards, like for setbacks and so forth, but the side and rear yards need to be only 4 feet, and those standards must be waived if they don't allow units of 800 square feet each. So what are some of the key requirements to qualify? The site has to be in a single family zone, can't be in a historic site or district. It can't demolish housing or even alter housing that has been occupied by a tenant in the last 3 years. That was to prevent displacement. As I mentioned, only objective standards can be applied. With urban lot splits, the split has to result in 2 approximately equal sized lots. One has to be at least 40% of the total lot size. Each lot has to be at least 1,200 square feet. The applicant has to say they intend to occupy the site for 3 years, and neither the owner and any person acting in concert with the owner, which is not defined, can't have previously subdivided an adjacent parcel to prevent people from, one developer from doing this on numerous adjacent sites. So what are the politics of this? First of all, there's a general recognition that there is a housing crisis in this state. In the legislature, though, the legislation is primarily written by market rate developers, and the cities seem to have extremely limited input, even into clearing up legislation so it's easier to understand. Most of us attorneys tear our hair out about all the ambiguities in the new legislation. And in the press, each of these measures is applauded. Counter arguments are viewed as NIMBYism. And one of the things that probably bothers me the most is there are periodically newspaper articles about how City X has perhaps met its above moderate income standards, but has not come anywhere near meeting its low or very low income requirements. And there's no acknowledgement whatsoever that it's impossible for the RHNA to be met throughout the state. There is not enough money to subsidize the lower income units that the state believes are required. Anyhow, with that, on that cheery note, I will end my presentation, and I'd be very happy to take questions.
Great, Barbara. Thank you very much. And I'm going to field the Q&A here. And the first thing I want to mention is for some of you that maybe joined us late, we are taking questions by you posing those questions and typing them in the chat box. Please do not raise your hand because we're going to be taking this in order of what we've got here. And I just pulled up the chat box. I want to first mention that MCL staff has posted the URLs, which are website links here to housing elements, affordable housing and fair housing, some things that Barbara put together that are critical to the discussion and presentation this evening. So I'm going to ask the first question. We don't need an icebreaker because I've seen that there's already 5 questions in the queue, but MCL got a really good question today from a member, and it seems to be really timely because it's real specific to Marin County and the housing elements and the fact that we have a lot of open space in this county. And the question was, will recent housing bills change the housing status of properties that are currently secured or in permanent open space? And it's a very good question because this county's done an excellent job at preserving open space, and that's its purpose. And yet a lot of communities are going to be forced to be looking at sites for housing. So Barb, can you provide us your thoughts on that?
Well, first of all, the state doesn't have any ability to change the open space status of any open space land. All the decisions about what sites are going to be designated for housing are made locally. So now, in terms of whether any specific site can, any specific open space site can be changed to be a housing site, a lot depends on how that site was purchased, what conditions might be on the site, what what limitations were in any deeds. So I think in terms of whether any particular site can be changed for, even has the ability to be changed from open space to housing, really depends on the conditions applicable to that particular site. As I said near the beginning, I think there's, given how tough HCD has been on cities, I think it's going to be a choice between, to some extent, changing the character of some downtowns or in Marin versus moving out into the open space.
Okay, great. Thank you very much. The next 2 questions have to do with water and infrastructure, which are very good. What plans are being made to provide water for more housing? A related question is, given these constraining rules, do they take into account infrastructure adequacy, water, sewage, wildfire, and earthquake risks? To some extent, I know they do in some of these bills. And then, of course, there's CEQA. I think you responded to some of this, but you might want to elaborate on this and see what your thoughts are with regard to at least the basics like water and sewer. So,
I mean, I actually don't know exactly what the county's doing about increasing its water supply, except what I read in the paper about the pipeline across the Richmond-San Rafael Bridge. Let's see, when a site is designated, the city or the county needs to demonstrate that it has either has adequate water and sewer, or that it'll be provided. There's some specific plan to provide it in the future. ABAG would say that in doing the RHNA, they have taken into account high fire hazard areas, and that they made some kind of a deduction. It's a very complicated formula that they came up with to do the RHNA, but that would be their response. At this point, really, the numbers can't. A number of the Marin cities, and I know the county, appealed their RHNA to ABAG. Those appeals were pretty much universally denied, and at this point, regardless of fire, earthquakes, whatever, those units are supposed to be accommodated.
Okay, moving on to the next question, another good question. Do any of these statutes apply in the coastal zone? I think you mentioned SB 35 and objective standards, et cetera, for by right approval. So is that correct, or are there others?
Yeah, virtually all the let's see, SB 9 does apply in the coastal zone. SB 35 does not. Virtually all the legislation has some kind of language saying something on the order of nothing in this legislation basically is meant to change, affects the Coastal Act. It's not worded quite like that, but it has language something like that. So the Coastal Act still applies, and local coastal plans still apply, and coastal development permits still apply, although in some cases, the state says no hearing is required, for instance, for SB 9 projects. Also, I would say that both I believe all the area within the coastal zone is in the county. So both the county and the Coastal Commission have somewhat more flexibility in applying coastal zone standards than cities have that are outside the coastal zone.
Okay, the next question has to do with what types of housing are counted toward the required number of units, the RENA. And the question is, do senior housing units, and then parenthetically, independent, assisted living, nursing home, count toward the required number of units? And you're smiling because I know this was a big question that has come up for years. And we in San Rafael, when I worked for San Rafael, we tried to lobby HCD to get assisted living units and nursing homes to be counted toward our RENA, and we were unsuccessful. So do you have some thoughts on this and can respond?
I mean, a unit can be counted as long as it's a dwelling unit. HCD allows junior accessory dwelling units to be counted, even though they don't necessarily need to have their own bath. But group quarters like dormitories, nursing homes are definitely not counted. With assisted senior housing, independent senior housing would count. Those almost always have some kind of kitchen facilities. And for assisted living, I think it would depend on whether the units are dwelling units or not. My dad was in assisted living where he had a small burner. Anyway, his unit, despite how small it was, I think would have been counted as a dwelling unit.
Got it. Okay. Next question. What about disability rights? For example, proximity to public transit isn't sufficient if there are no or unusably dilapidated sidewalks. So that's a really good detailed question. So because you have, we are in Marin here, we have a lot of areas that don't have sidewalks, even though they may be a half mile to transit. So
the statutes don't really deal with that. I mean, I think some of the ability for people not to have parking would actually make it extremely difficult for physically disabled people to have access to any kind of transit whatsoever. But the statutes don't require that. At best, they require walking. They require like a half-mile walking distance. But there's no, assuming you can't walk on a freeway, but you can walk on a road. So I think that would probably qualify, but the statutes don't seem to deal with that.
What's interesting about a lot of these laws is that they're drafted, they're signed, but in many ways they are not played out. So what you find is that something doesn't work because we deal with a one-size-fits-all law. And then inevitably the next year, the legislature comes in and amends the bill because they see where the holes are. And that's happened numerous times in the last 5 years on some of these bills under the Housing Accountability Act, et cetera. So questions like this is when you dive into the details on how this stuff practically works, you're going to find something that, is not addressed. One of the questions here is, will the presentation slides be sent to attendees? When we started the webinar this evening, we indicated that MCL will be working to post the webinar, which will include the slides either in a YouTube form or some other form. So stay tuned on that. Next question, will a conservation easement on a parcel prevent development under new laws? Very similar to the open space question.
Let's see, I'd have to look at the particular language, but a lot of I think both SB 35 and SB 9 do not allow cannot be used on area with a conservation easement. And also if a city when it designates a site for housing needs to show that the site is developable. So if a site has a conservation easement that doesn't permit the housing, really would not be able to designate that site.
Okay, moving on to the next question. Isn't it true that SB 9, which is the lot split legislation, only applies to census designated urban areas, thus eliminating much of rural Marin?
That is a good point. It has to be let's say, it has to be an urban area, or it can be an urban cluster, which is another census designated area. So that somebody, I assume somebody at the county has a map of what an urban cluster might be. But it doesn't have to be incorporated. It can be an urban cluster. So yes, it is probably correct that much of the county is not in an urban, of the unincorporated county is not in an urban cluster, and so SB 9 could not be used there.
Okay, next question. Have there been legal challenges to these statutes based upon ADA? For example, the parking issue that Barbara, you mentioned.
No, I'm not aware of anybody challenging them based on that. I should mention there was a bill that failed last year that I've heard will be reintroduced, perhaps not, which would have forbidden cities from having any parking requirements within a quarter mile of public transit. But that kind of a bill would raise some of the same issues. But I'm not aware of a challenge based on ADA.
Okay. Next question. Do any of these new laws make it more possible to use eminent domain to achieve RENA goals?
No, none of them say anything about eminent domain.
Okay, I've got those are the questions we had in the chat box. Let's see, there's one more here coming in. If development of a property was blocked by a citizen's referendum, is the property exempt from new housing laws? For example, Fairfax Town and Country Club property.
You can't right now adopt an initiative that downzones the property. The Housing Crisis Act applies to initiatives and referenda as well as to just city council or board of supervisors actions.
Okay. All right. So we don't have any other. Okay, one more is coming in here. Let's see here. Does any of the legislation impact priority development areas differently than non-priority development areas?
No, not right now.
No, but I do want to comment on that because before I retired, we worked on a downtown precise plan in San Rafael, which is a priority development area, and we intentionally upzoned a lot of properties with the understanding that the RENA was going to jump, the regional housing need allocation was going to jump. So the priority development area was used as a tool to do that upzoning. So that was backhandedly handled, but it's not that the legislation applies to that. The intent of priority development areas, though, is to look at those areas as opportunities for more housing and more jobs. Next question, why hasn't the state made more provisions for subsidizing affordable housing so that cities can meet these goals? Great question. If most affordable housing has to be achieved by inclusionary zoning, that would require a huge amount of market rate housing, well more than what is required in the RENA numbers? And this is a very good question, particularly with regard to money coming from the state now to help assist in getting housing built. So, but we don't have redevelopment agencies anymore and things of that, tools like that, that make this helpful. Do you have some thoughts on this, Barb?
I mean, I talked about that a bit. I mean, the state has been increasing the amount of money for housing, particularly for homelessness. I think because it's so visible with the tent encampments. Why, you know, I think it's been, there's such a meme in the press right now about the cities being responsible for the lack of enough, you know, for not building enough affordable housing. You know, that seems to be where the blame has been shifted to, cities and the counties. So I think people aren't really aware of how much it costs to build affordable housing. I read that in San Francisco, it's almost $1 million a unit to construct affordable housing. You know, and prices have gone up to such an extent, construction costs and everything else. You know, it just somehow that link that it's impossible for the cities to do it without more money has just not been, you know, I don't know, the link has just not been made.
Most of the money that's trickled down from the state is really to assist local jurisdictions in their housing element development and a few other things. I do know, and I believe there is some sort of a accessory dwelling unit fund that may have been set up at the state level to assist homeowners, but I don't know much about the details, so I don't want to speak out of hand on this particular question. So
I think there's a bill, I think there was a bill to have the state look at providing additional assistance, particularly to lower income homeowners, to build accessory dwelling units, ADUs. I just saw an article that said most accessory dwelling units in San Francisco had been built in wealthy areas, which is not actually surprising because they're expensive, you know, they're expensive to build. You have to have some kind of expertise. So there is that, so the state is supposed to be looking at it, but I don't think it's active yet.
got it. We've got a couple more questions here. If a property is subject to a demonstrable hazard, such as a designated high hazard zone, should it be excluded from consideration as a housing site?
Should it be excluded from consideration as a housing site? I mean, I think you would need to know what your options are, right? In SB 35 and SB 9, there has been some press that areas in high fire hazard zone, very high fire hazard zones are excluded, but that is actually not what this legislation says. It basically says that they have to meet state fire marshal and local building code standards, but it does not exclude them right now. There was a bill that the governor vetoed that would have really taken high fire hazard much more into account in doing the RENA and in, you know, and tried to discourage cities and counties from approving developments in those zones. But the governor vetoed it. And ironically, the Attorney General has been involved in at least 3 lawsuits trying to stop projects in very high fire hazard areas. The most recent one is the one in Lake County, where the Attorney General intervened and the Superior Court judge decided that the evacuation routes hadn't been adequately studied in the EIR. But so we have on one hand, you know, great pressure on cities and counties to provide more housing, but the Attorney General filing suit regarding thousands of houses because of the fire hazard, which I understand. But it's a real balancing act.
Got it. Next question, do boats and houseboats count as ADUs, accessory dwelling units, under certain circumstances? Interesting question. Also, it's a good question. Do they count for RENA purposes too? So do you have any comments about that?
I don't know what HCD does with boats. I would think that houseboats would count as dwelling units, though.
Yeah. Well, I can tell you, I remember at Loch Lomond Marina, there's 500 plus berths at that marina, and the Bay Conservation and Development Commission required that 10% of those berths be set aside for liveaboards. And because they had the facilities for wastewater pump out, water connection, restrooms, things of that nature, that made it desirable for someone to live there permanently. So they did make that. So I don't know if the city got RENA credit for that, but it certainly was something clever that I thought BCDC did. Next question, any restriction on ADUs being converted to short-term rentals? Good question.
A lot of cities have that provision in their ADU ordinance, that ADUs can't be used for short-term rentals. And SB 9, no SB 9 building can be used for short-term rentals. That's in the state legislation. The state legislation on ADUs also does not allow, says that certain ADUs cannot be used for short-term rentals, but I think it's pretty common for cities not to allow short-term rentals.
Oh God, maybe the next question should go to the state auditor. Over the past 4 years, what is the amount of campaign donations given to the state legislature from market rate construction developers and housing labor unions? I don't think any of us
I
can
don't think I
answer
can
that
answer
question.
that question.
Yeah, right. Good. Okay, moving on. Since CEQA does not treat policy, but merely discloses what the lead agency presents, general plans and other sources, the requirements for standards to be quantifiable is really a cautionary notice to lead agencies to quantify any identified impact and proposed mitigations. This is not really a new issue for preparers of environmental documents. That's a good comment.
Yeah, that's a good comment. The statutes almost all, unless they specifically provide for ministerial approval or say that a project's exempt from CEQA. But the statutes, for instance, the Housing Accountability Act says specifically that nothing in the act basically is intended to change the findings that cities need to make when they under CEQA.
And the next one is a general comment. Actually, this is a good comment. Sausalito had slips for liveaboard boats approved for low-income RENA fulfillment in the last cycle. So that's
Great.
terrific. Hail to Sausalito for that. Same comment about there's another comment from Vicki Nichols, same comment about these boats. Next question, what effect, if any, would Novato's voter-approved urban growth boundary have on designated housing sites?
So one of the things in the Housing Crisis Act of 2019 was an effort to ban growth caps or growth control ordinances that meter housing development. However, it says specifically that urban limit lines remain. So, without knowing specifically, was this a question in terms of the county or the city? I have to say I'm not familiar with Novato's growth, urban growth boundaries, so I don't know if it's located in the county or if it's located within the city.
From what I understand, and maybe the person that posed this question, Don Dickinson, if you want to elaborate on this, but I from what I recall is this is the city of Novato adjusting their urban growth boundary lines, some of which affecting unincorporated lands within their sphere of influence. So, and again, I don't know the details of that proposal or that voter approved action.
I mean, I would say in terms of Novato's own actions that they would need to comply with the urban growth limit in terms of the county's action, because they're not, without really knowing any of the details. I mean, it's possible that the county could designate sites within or outside the urban growth boundary, if they need to have, designate more sites. I mean, the number of units that the county needs to designate is pretty amazing. It's got, 3,500 units in the unincorporated area.
That was the last of the questions here that we've gotten. Did you want to say anything else, Barb, before we wrap this up tonight?
No, not really. I would encourage people to get involved with their local housing elements. That's really going to set the stage for the housing development in the county and where it's going to be. I think it's going to be really difficult for the cities in the county to find enough sites to meet state law. And it's, to some extent, it's going to be a trade-off. And I think it's going to require some fairly major changes in zoning and planning in Marin.
Yeah. Okay, great. Well, listen, a big thank you for being a guest speaker this evening on a very timely and interesting topic that we're facing, and much appreciated for the time and effort that you put into your presentation. And this has been very educational. So thank you again, Barb, for doing this for us.
Thank you very much for having me, Paul, and Marin Conservation League.
Absolutely. Okay. And I just, as we close up here, I just want to remind everyone that we did post the URLs in the chat box. And again, we're going to take this webinar and it will be either posted on YouTube or some other forum. And I want to thank everyone for participating. I'm looking at the list of the participants. Many people I know, and I know that they're very interested in this topic. So it was great to see such a big turnout this evening. So thank you again, everyone, for taking the time and joining us. Have a good night.
Thanks.